Welcome everyone to our estate planning webinar. I am Scott Caskey. I'm a CFP here at Summit Investment Advisors. And we're partnering today with Cory Wessman, who will be our speaker. Cory Wessman is an attorney and shareholder with the Minneapolis law firm of Erickson and Westman, PA. Cory practices law exclusively in the areas of estate planning and trust and estate administration. With that, I'd like to welcome Cory for the presentation.
Great. Well, thank you so much, Summit Investments, for this opportunity to talk about estate planning. Thank you for taking time out to discuss something that is not altogether real exciting for us, planning for the eventuality of our disability and our death. So I thought I would take some time today to share from a legal perspective those things that are important to allow for the management of assets during your lifetime and in the event of your incapacity and then following your death. So today's presentation is intended to provide you with some food for thought, some tools to think about with regard to your own estate planning matters, and then hopefully to apply those things to your unique situation so that whether now or at some point in the future you can have your estate plan updated given your unique financial and family situation. I'm always careful to point out that in terms of leaving a legacy, this is just one aspect of what I think to be a comprehensive aspect of legacy planning. You know, we might have certain things that we wish to accomplish on this earth, whether relationship-wise or professionally. The things that I'm going to talk about today are, of course, just related to financial and legal affairs as it relates to leaving a legacy. And so I just want to take that aspect of comprehensive estate planning and talk about it a little bit today. So very briefly, the overview of our presentation, I'm going to talk about some planning tools that we can use regardless of your family or financial situation, certain things that I would recommend that you have in place. I'll talk very briefly about taxes. I don't want to spend too much time on that because in your particular situation you may not have the same tax issues as your neighbor or even your siblings or friends, and every situation is different. So I just want to give you enough information to be helpful and to think about proper estate planning, and then I'm going to talk about some charitable and tax planning strategies. So when I meet with our clients who are anywhere between age 18 and 118, I say there are 3 documents that you'll need to have in place, 3 of them, and 2 of them actually relate to not what happens in the event of your death, as important as that document is, but 2 of the 3 relate to what happens in the event of your incapacity. So as I start thinking about an estate planning overview, one of the main questions that we have as it relates to estate planning is who has decision-making authority for you, both during your lifetime, that is during a period of mental incapacity, but also following your death. So just very generally, very broadly, estate planning includes or incorporates who are your alternate decision makers, and we'll talk about that a little bit more in a second. Estate planning would also incorporate who are recipients, who are the recipients of your assets in the event that you pass away with anything of value to your name. And then, of course, the question is, when do those beneficiaries receive assets? I mentioned briefly that 2 of the 3 documents that all of my clients, prospective clients, should have relate to planning for your mental disability. And these are your so-called alternate decision makers, your power of attorney, and your healthcare directive. Your power of attorney is the document that allows you to designate a representative or an authorized agent to be able to make decisions for you if you're alive but incapacitated. So for my married clients, I typically recommend that you prepare, or you have prepared, and that you signed a power of attorney document that permits your spouse to be able to make legal and financial decisions for you if you are alive but not able to make your decisions by reason of mental disability. With the power of attorney, we generally recommend that you name a backup or a successor agent to serve if your spouse cannot serve. And of course, if you're not married, I likewise recommend both a primary and a secondary agent. A healthcare directive is also a document. Two of my three documents that like I say, I recommend for all of our clients. A healthcare directive is the second of the three documents. The healthcare directive allows you to designate one or more individuals to be able to make healthcare decisions for you if you are alive but not able by reason of your own mental disability to make your own healthcare decisions. So like the power of attorney, I recommend that you designate a primary agent who would presumably be your spouse if you're married, and then one or more backup agents. So I touched on the topic that's difficult for us to think about, but in this age of medical technology and an age when we are living longer and longer, planning that is of critical importance, I think, and that is to say, who are your alternate decision makers if you are alive but not able to make your own decisions? And I know that the folks here at Summit and other folks in the financial industry would say that it is critically important in the event that clients become incapacitated that that be spelled out so that they can abide by the authority vested in a certain person to make financial decisions on your behalf. So again, two of the three sort of basic estate planning documents are planning documents that actually relate to what happens during your lifetime in the event that you're alive but incapacitated. Now let me turn to something that you probably were more prepared to listen to today, which is what happens in the event of your death. And so this is the part of our webinar today talking about what happens in the eventuality of your passing with regard to the assets that you own. And I want to make sure that as I go through a brief discussion of these tools that you understand that all of these tools are tools that are utilized and implemented, I should say, following your death. And what I mean by that is that you would always have the legal right to use, enjoy, give away, spend your assets during your lifetime to meet your needs during your working years and, of course, during your retirement years. So none of these things are sort of set in stone. One of the more common questions or concerns and, frankly, sources of misinformation as it relates to estate planning is really around what a will does. And so leave it to a lawyer to give you a long-winded explanation of what a will does, but I thought it would be helpful to categorize assets generally so that you have an understanding of what a will does and does not do. A will controls only certain types of assets following your death. So a will would be effective following your death. Your last will that you signed would be the will that would be legally effective to control the transfer of assets following your death. Only those assets that are considered part of your estate would be controlled by your will. And your estate are those assets that are considered to be probate assets. Maybe the best way to explain what a probate asset is to say that it's a type of asset that has not already been dealt with through another legal means, through another way. So on this slide that I have, I refer to various types of non-probate assets. And these are the types of assets that would not be legally controlled by your will in the event of your death. most common example that you're familiar with probably is survivorship rights on jointly owned property. So if you and a spouse co-own a home, a bank account, other assets, by reason of that legal attribute, in the event of your death, your surviving co-owner, spouse or child or whomever the other co-owner is, would automatically become the owner without respect to what your will says. So it's very important to keep that in mind. Your so-called beneficiary designation is the agreement you have in place with the administrator of generally a retirement account, 401k, other deferred compensation plan, or life insurance company for the transfer of your assets following your death. That is a non-probate asset in the sense that under the terms of that beneficiary designation, your beneficiaries, that is to say those individuals or charities that you've named under that designation, would become the new owner of your assets following your death by simply providing a death certificate and some paperwork from the administrator. So that does not require the so-called probate process, which is the court-supervised process for the transmission of assets following your death, and thereby it does not require the use of a will. Finally, POD or TOD designations, that's short for payable on death or transfer on death designations. Those are commonly found with a bank account or an investment account. That would allow you to, like a beneficiary designation, designate one or more beneficiaries to be the recipients of those assets following your death. And again, that particular designation would control over what you've said in your will. Finally, a revocable trust is an agreement that you would create during your lifetime that would own certain of your assets. I'll talk about this a little bit more in a moment, but the idea that I just want to leave with you now is that if you have an asset owned in a trust, then that trust agreement, the legal agreement that controls the revocable trust, would govern and not your will in the event of your death. So your will is important in that it allows for the direction, the legal direction of those assets that are considered to be part of your so-called probate estate. And as I've tried to summarize for you here, not all of your assets are necessarily part of your probate estate. Only those assets that don't pass by a beneficiary designation through joint ownership, through a TOD or POD designation or a trust would go through a will. And I generally recommend that regardless clients have a will, just because there's some symbolism associated with a will and a direction, and in any event it's sort of an insurance policy against having certain assets already in one of those non-probate type of accounts. Probate sometimes gets a bad name. Let me just briefly describe what probate is. Probate is just a court-supervised process of transferring assets following your death. It's not to say that the government receives a greater tax revenue or the government receives it all. It means that there is a supervisory function of the court system over your remaining assets. And I think the worst that can be said for the probate system is that it just takes longer to administer those assets and to distribute them to the designated beneficiaries than if the assets pass by one of those non-probate means that I described earlier. Stock, a question has come up, what about stock? And stock is could be owned in a retirement account, say a 401k or an IRA, or if it's owned in a managed or taxable account. Usually those are just individually owned, and so that's a good example of an account that would fall under the category of a probate asset. So if you had an investment account that was not owned by a trust, generally speaking, your will would control the transfer of that stock following your death, because that's considered to be a probate asset. So on my next slide here, I just thought I would share with you some tools that many of my clients use to address their estate planning objectives. So in their unique family and financial situation, here are a few tools that you might consider. And these, as opposed to my cartoon here where we're generating huge legal fees as the attorney, hopefully these are somewhat basic tools that every family can sort of implement. As part of your estate plan, usually a will, you would want to designate a so-called personal representative. And that personal representative is in charge of collecting your assets, paying your expenses, including post-death expenses like funeral expenses, and then making distributions to and among your beneficiaries or the people that you want to benefit. If you have young children, as I do, who are under age 18, you would want to designate a guardian who would be responsible for the care and custody of your children in the event that they're not yet to age 18 and you and your spouse or the other parent of that child is also deceased or is not able to stand in as the parent. The trustee is the designation that may or may not be applicable in your situation. I would describe it as the person that you've named under your estate plan to be responsible for the ongoing administration of how an inheritance is distributed following your death. So the trustee would be responsible for, say in my case, I've got 3 young kids, and they're of an age where they're not able to independently make decisions for themselves. So in my case, the trustee would be responsible if my wife and I passed away to take the inheritance earmarked for their benefit and then make decisions in terms of investments, filing tax returns, and then making distributions for the benefit of each child. So those are the 3 key individuals that I recommend that you consider as part of a good estate plan. Now, related to that particular scenario that I just described, that is to say a scenario where you want to benefit certain individuals, but you have concerns about how they're using or going to use the inheritance they receive following their death, you may consider a legal structure that I call a testamentary trust. And what I mean by that, it's a legal entity called a trust that's created under the terms of your estate plan that would benefit certain beneficiaries. Since I'm giving a webinar today, I can show off a picture of my daughter who's there on the right side of your screen. And she's obviously of an age where she cannot manage her assets. She does indeed look like trouble, and she's every bit as much trouble as that picture looks. The picture on the left side is not any of my kids, but I thought it was apropos to our topic today because you can imagine how this works. Somebody's painting, they leave the paint in the living room, and next thing a child's artwork is all over the wall. But I show this picture because many of my clients, both who have young kids like I do or adult children who have demonstrated perhaps have demonstrated inability to manage finances, or perhaps through circumstances even outside of the child's control, there are reasons why you may want to have some legal structure around how a beneficiary receives assets following your death. So conceptually now, the benefit of a testamentary trust is that you can, under your estate plan, create a structure following your death in which you are naming a trustee to manage remaining assets for the benefit of a beneficiary. So again, going back to my own estate plan, we have a plan in place that would allow my brother-in-law as the trustee to receive our remaining assets when both my wife and I pass away, to manage those, invest those, file tax returns, and then make distributions to the beneficiaries. So you see the boxes here on my slide. I want to carefully distinguish between the trustee, who is sort of charged with the thankless task of doing all this for the benefit of the beneficiary. And the trustee would be the one who actually holds the legal title to your assets, but it is for the legal purpose of providing for your children, grandchildren, or other beneficiaries. So again, I hope that's helpful to think about. Just very quickly, one other planning tool that I want to reference is one planning tool that I mentioned in passing earlier with regard to avoidance of probate. And again, probate is just that process that's associated with the transfer of your assets if you have assets in your individual name and not passing by reason of beneficiary designation or by the fact that you have a surviving co-owner. Many of my clients come into my office, or prospective clients come into our office and say, we want to avoid probate. We want to avoid that additional step of having to go through the probate court process to transfer assets following death. And so depending upon the situation, we'll say, let's create a revocable trust. A revocable trust is not the beneficiary of your estate per se. It's merely the legal vehicle by which you're able to take your assets, have them owned in a manner during your lifetime that you continue to own and control and benefit from those assets during your lifetime. But it's all set up so that in the event of your death, we avoid probate and we can have the right structures in place, including perhaps the use of a testamentary trust for certain beneficiaries following your death. So a revocable trust is, as my little image shows here, often considered to be like a moving truck, that you just use a legal entity called a revocable trust to own your assets and allow for the transmission or the transfer of your assets to your designated beneficiaries following your lifetime. So the benefit of a revocable trust is that you can avoid the probate process by having assets in your trust, not in your name. And again, the legal significance of that is because the revocable trust is an agreement, legal agreement unto itself. Because it survives you, there's no probate that's necessary if certain of your assets are owned in the trust at the time of your death. So the advantages are avoidance of probate. It protects your privacy. There's no public disclosure following your death about what is the nature and extent of your assets. Now, in order to really make revocable trust planning worthwhile, it's necessary that you not only retain or hire an attorney to create a trust for you, but you actually also transfer the ownership of certain of your assets to your trust during your lifetime. So it's a little bit more of a hassle for our clients during their lifetime to work with their banker or their financial advisor to transfer assets from your name or your joint names into the name of your trust. Now, with my office and Summit, it's usually a pretty easy process for our clients to just sign the paperwork to transfer it over once the trust is signed, but it does entail a little bit more of a cost and a hassle than it would otherwise be the case. But depending upon your circumstances, it is an excellent tool for our clients to really avoid the probate court process. I'm going to touch very briefly here on taxes. The rest of the materials here relate to taxes, but I just want to mention a couple of things related to taxes and sound estate planning. I think good estate planning takes into account your particular financial situation, your objectives, who your beneficiaries are, and coordinates the tax-related issues with the planning. So now I've already shown off, well, let me say I've shown off my daughter already. Now I'm showing off a picture of all three of my living kids here, and then Uncle Sam and Church or Charity, of course. But very briefly, in terms of taxes As it relates to estate planning, you of course can give to family or friends, you can give to government, or you can give to charity, one of those three buckets. To the extent that you try to fill up the bucket on the left hand side, that is family or friends, you're going to generally fill up a little bit more on the government bucket. To the extent that you give to charity, then you are cutting out, in this case, the middleman or Uncle Sam. And so I happen to be a big believer in nonprofits and love it when we can work with clients to allocate assets to charity, and in so doing you are minimizing income and estate taxes. Very briefly again, two different sets of taxes you may or may not need to be aware of, or at least be concerned about. You should be aware of them, not necessarily be concerned about them, but in terms of being aware of taxes as they relate to estate planning, income taxes is the first of the two layers of taxes. And the good news is, for most types of assets, when your beneficiaries receive assets following your death, and the same principle actually applies for gifts during your lifetime, your beneficiaries do not pay any income taxes on those gifts. So they should not even report those gifts on their income tax return. The exception would be, and this of course, this small exception is getting to be a bigger and bigger exception because of the value of tax-deferred retirement accounts, but the big exception is tax-deferred retirement accounts. The exception there is based on the idea that because you haven't paid income taxes on accumulated earnings within a tax-deferred retirement account or tax-deferred annuity, then as your beneficiaries receive those remaining account assets following your death, they must pay income taxes on them. So that's just something to keep in mind. That principle's not true, that rule's not true if you are allocating remaining retirement account assets to charity. So as charities receive remaining retirement account assets, they receive those remaining retirement account assets dollar for dollar without a reduction in income taxes. The other layer of taxes is estate taxes. And in my handouts here, I've got various rules about estate taxes. Most of us don't need to worry about estate taxes. And the reason for that is that we can give a certain amount, the legal term for it is an exemption amount, without having assets subject to estate taxes. You'll see on the slide there that at the federal level, that's now $5.45 million per person or per estate, which means if you're married, your spouse also has the right to give another $5.45 million free of federal estate taxes. The rule at the state level, so if you're a Minnesota resident, you would face the possibility of a state-level estate tax. The exemption there is $1.6 million. So the idea there is that if you and your spouse, as of the second death between the two of you, have more than $1.6 million, then your children, grandchildren, other non-charitable beneficiaries would have an estate tax. There are some strategies that can be implemented both by way of lifetime gifting as well as under the terms of your revocable trusts that could minimize the incidence of Minnesota state taxes. I work on a daily basis with our clients who are above that threshold to do what we can by way of lifetime gifting and other strategies to minimize that Minnesota estate tax exposure. I do have some additional slides here in the handouts here that you can review. There is a slide that shows how the Minnesota estate tax exemption amount will be increasing in each of the next 2 years, so that by 2018, again, if you're a Minnesota resident, you have the right to transfer at your death up to $2 million without any estate tax exposure at all. Now, in the right-hand column there, I have listed the rates that would be applicable only in the event that the value of your assets are in excess of $2 million. So you're looking at somewhere between a 10 to 16% estate tax exposure on the value of the assets that are above that $2 million exemption. I do have some notes in here about some of the changes that were made 2 years ago when Governor Dayton signed a new tax bill into law as it relates to Minnesota estate taxes. And then finally, I do have some slides in the presentation related to tax planning tools. The two concepts that I reference are fairly straightforward in principle, and that is that if you are concerned about estate taxes, the strategy would be to give away assets as soon as you can. Under Minnesota estate tax law, there's now a rule that relates to when you made the gift in comparison to your death and the imposition of Minnesota estate taxes. But the only thing I think you need to remember is if you're considering making a gift, you should do it sooner rather than later. And I have some illustrations as to why that would serve to minimize estate taxes. And then lastly, charitable planning. A number of my clients are charitably inclined, and so for those clients, for those clients of ours who are charitably inclined, it does make a difference which of your assets go to charity and which go to your children, grandchildren, nieces or nephews or other non-charitable beneficiaries. In short, the tax concept is that your tax-deferred retirement accounts, annuities, other assets that I mentioned before that would trigger income taxes following your death should be allocated to charity. So I have a hypothetical here that I reference. The idea here is that if, for example, you have a retirement account and a home and you are charitably inclined, it would be better to allocate a greater percentage of your remaining retirement account assets to charity rather than children, keeping in mind the same overall percentage applies in this hypothetical. But the idea here is that you're minimizing the income tax burden on your kids. So I am an attorney in Northeast Minneapolis here, not far from Summit. I think it took me 5 minutes here this afternoon to get over here for this webinar. So we represent a wide range of Minnesota, Wisconsin, and Arizona clients with regard to their estate planning matters. I've got my contact information on the slides, and so I'd be happy to answer any questions, email, telephone, and thank you again for sitting in on this webinar over your lunch hour.